Good evening. Good evening, all of you.
Good evening, sir.
Yeah, it's my pleasure to invite you all for this small interactive session on this labor law course. I hope, 1 minute, I mean, it is better you introduce yourself so that I will know you in depth. Mr. Asif, you can start, introduce yourself.
Good evening, everyone. I'm Asif Karim Sahir, a resident of Udaipur, Rajasthan. I did my MBA in Human Resources from Aligarh Muslim University in the year 2004. After that, I worked with Vedanta for half of a year as a project trainee, and then I joined JK Lakshmi Cement Limited, Sirohi plant, and I was working there for the past 15.5 years.
Oh, great.
Yes, sir.
Okay.
Sir, I do not have any exposure in the field of IR. I was looking after HR activities, learning and development, customer and culture, employee engagement. So in December 2020, I took a break from the corporate. And since then, sir, I'm studying about IR.
Oh, very good.
So sir, I had the pleasure of attending 2 of your sessions, which you did in October 2020 for the NHRD ER course. So you took 2 sessions.
Oh, so, yes, I remember. Correct.
I was very excited, sir, when I saw this brochure that you are conducting this course. So I wanted to join and learn the most from this course.
Oh, yes, that's very nice. That's very nice.
Thank you. Thank you very much for having me.
Oh, yes, sure. We'll continue. I will help you as much as I can. Right? Okay.
Thank you very much.
Mom, Mr. San.
San, you please unmute yourself.
Unmute.
Am I audible to you?
Yes.
Yeah. Good evening, everyone.
Good
evening. I'm currently deputy manager HR. I'm working with Duraflex Private Limited in Oslo.
Oh.
I have 9 years of experience in HR and IR domain, sir.
Oh, good.
So that's the small introduction. Okay. Basically, I'm from Tamil Nadu.
Tamil Nadu, placed in Hosur.
Yes.
Okay, that's very nice. Mr. Dippada?
Yeah, good evening also. Actually, currently I'm associated with SA Group of now, SA Digitronics. I have a total 12 plus years of experience in HR. Of course, even I don't know much exposure. I didn't got any exposure to related to IR. I just want to learn something at least from IR issues in this session. Currently, I'm taking care in HR activities. I'm totally zero in IR. I practical things.
Okay.
I just want to learn more about IR things.
Mr. Prabhu?
Good evening, sir. Currently, I'm associated with SA Gears and Transmissions, Ramasandra. I'm looking after HR and IR activities in the plant. I'm having around 10 plus years of experience in HR and IR.
Oh, good. Okay, that's very good. Mr. Prakash?
Hi, sir. Good evening. I am Prakash. I am currently working with Robert Bosch Engineering and Business Solutions Private Limited, which is located in Bangalore, Koramangala. Yeah, I have almost 15 years of experience where I will take care of compliance and contract labor management and medical.
Oh, yes. Oh, that's very good. Yeah. Very good. Mr. Subbu?
Hi, sir. Good evening. Can you hear me?
Yeah, sure. Yeah.
Yes, sir. I have more than 9 plus of experience in HR and admin. Presently working with the Creator India Private Limited, where I'm taking care of entire HR as well as admin operations. We are into German-based premium kitchen appliances company. We have a sales and service team across India. So corporate office is Bangalore, Shantinagar. So I'm handling entire HR operations and plus as well as admin operations for all the employees from corporate office.
Okay. That's very nice.
Thank you,
So,
sir.
okay, we will start. This labor law course, what we are planning, what I conceived about 5 years, 6 years back, and is doing it. This only to promote your competency in the area of labor legislations. Because what happens being in HR, whatever the domain of work you do, you want it to have not only an exposure to labor laws, but as much as possible deep knowledge in this. Because every day, you come across a lot of issues, you come across a lot of problems. Normally, what we do, any issue comes legal, then we just refer it to a consultant, or you ask a consultant to draft this thing and come. Even small things we go there, but the thing is, we should never do that. We have to have the competency developed among ourselves. We must do that. Once we do it, what happens is that you become a master of the entire thing. I don't say that one has to become a total advocate on this, not required. But at least we should have at least 80 to 90% of the competence level, we should have this one. It's a continual effort. I'm sure labor legislation is a continual exercise in the sense that every day it changes. Every day a lot of changes comes. Every day a lot of interpretation takes place. Though amendments are not there, various courts of law give different interpretations, and we should be up to it. For that purpose, if you have basic knowledge of the entire legislation and added to that review of all the case laws, whatever comes every month, then what happens? You gain your competency. Then you will be able to advise your management, advise your colleagues, or advise anybody that what is right, what is wrong, what is legal, what is not legal. Then you can definitely advise on this. So this is the purpose of the entire session, and as much as possible to give you in detail. Of course, probably I think by now you would have gone through the presentation material which has been sent by Mr. Ramesh during the last 10 days. I hope we have gone through that. Now, basically, I will just give a brief background of the entire legislation in India, how it evolved, just for information. You see, what happens, as you know, India prior to independence, prior to independence, when it was ruled by the British government at that time, see, the India faced a lot of issues, particularly labor faced a lot of issues because, the independence movement also clubbed into it. And India, on account of the effects of the First World War, and on account of limited employment capacities, lot of what you call influx from rural to urban was taking place. When they come to urban area, what are the problems. Number one is that they can't get the accommodation, they can't get this one, they have to live somewhere, and the cost of living is terrible, and the wages what they get is nothing, and then there's no care for health, there's no care for hygiene, and all cares were taking place. And actually, there was no specific working time, working hours, employment of women, employment of children, employment, everything was totally under different casts. So hence for this purpose, as early as 1881, the government at that time, they thought, okay, we'll bring small legislations on Factories Act. The first legislation brought in 1881, Factories Act, but this was not adequate in the sense that it did not address many of the issues, like particularly safety, health and hygiene and working conditions, it never addressed. Second thing was happened, the Britishers at the time, since they were not, did not know how to recruit, they did not know the people for recruitment, they used to give the task to the agents, like our contractors, right, what we call today, the agents they were handing over. The agents used to supply labor to these British managed establishments or factories or whatever it is. Then the responsibility payment of wages was on the agent, though nobody was having a control on that. How much he is paying, how much he is doing it, and what are the coverage, and nothing, no absolute control. Working hours, this one. So what happened? This led to a lot of issues. And one of the prominent trade union if I'm correct, somewhere in 1889, one prominent trade union leader, I forgot the name, he took the interest and then showed some protest on behalf of the exploited workforce in India. On account of that, some activity started. Then the most welcome thing was that the British government at that time, they appointed a commission. This is called Royal Commission, Whiteley Commission. They appointed. They asked the commission to go into details, study the conditions of labor, and give suitable recommendations to the British government so that we can bring something. In fact, the commission did a fantastic, excellent work in this direction, and they traveled throughout the country. They interviewed a lot of people. They know everything, and then they made a strong recommendation on. Now, on account of this recommendation, that is the starting point of, I should say, the industrial jurisprudence in India. That is first step of development. The moment this report was sent to the British government, they had a parliament meeting, they approved and all that. On account of that, today, on that day, 13 legislations were passed and made implemented. The legislations are mainly updated the version of the Factories Act, then the Payment of Wages Act, Minimum Wages Act, and Employee Compensation Act, Trade Union Act, and Mines Act, Plantation Act, whatever name it, it all emerged out of that. Now, friends, this is the starting point of industrial registration present in India. Now, afterwards, what happened? The moment the independence came to India, then India wanted to make the country as a one of the most industrialized country in the world. That was their ambition. With that, they started. They also focused on many aspects. For instance, what is the improvement we can bring? What is the solution we can bring? So on kind of thing also, the activity started. They formed a lot of small groups of experts, groups of its own, and then they took, and then they started the whole thing. Now in India, what happened on account of that, a lot of development took place, and today we are seeing a lot of legislations. Now, one of the most important thing is, friends, you must remember that Indian labor legislations aims at social justice. Social justice. Now, social justice means that it's what you call equitable law application of law. Whether it is X, Y, Z, whatever it is, it equally applicable. Number one, it aims at the enhancement of standard of living of a person, of the worker, and to take care of his health needs, and then the medical facilities. And in case of accidents, what are the type of compensation a person can get in all the areas of work? And what about his family? How far it is covered? And what are the security schemes, in the sense that every day, whatever the money he gives, he cannot spend it. It has to be saved, a compulsory saving. It has to be emerged out of that. So this is the purpose of the entire liberalization in the country. So India is a peculiar thing that, in fact, in one of the judgments of Justice Krishna Iyer long back, he said that the industrial jurisprudence is not a static one. It's not a static one. It is highly dynamic. Highly dynamic. It means that it goes on changing, like, for instance, changes what is taking place in and around the society, the whole thing should be changed. Then only people will get the justice and benefits of it. So this is a highly dynamic thing. So there are two main principles on which the labor laws are framed in India. Broadly, I can give two classifications. One is that what we call, there are two concepts. There is called courts of law and courts of equity. That's what we feel. Courts of law and courts of equity. Now, courts of law means what happens is that the courts interpret just like a contract, strictly contract, no application of anything. I will give you a simple example. Let us say, for instance, a person commits a thief, or person assaults somebody on the road. then what happens? He is governed by the provisions of the Criminal Procedure Code and Indian Penal Code for the purpose. So immediately police files an FIR, it goes to magistrate. The magistrate will, of course, will see whether the acts of offense is substantially proved or not, he says. But when he gives the, what you call the punishment, he does not look into the social aspects of the person. He doesn't look into it. You have committed a murder, okay, this is the position. If you have done it, this is the position. If you have committed theft, this is the position. So there is no question application of the mind into his personal background. Why he is doing it? What is the reason behind it? Is it due to any compulsion he is doing it? Or should we take any, what you call, a liberal view of the entire thing? No, it's purely a court of law. Whatever the legislation says, section 402, for section 420, like this, it goes on, goes on, goes on. This is what is called courts of law. Now, coming to industrial jurisprudence, on industrial side, this is all called courts of equity. Here, what happens, the principle of the labor legislation, as I said already, it is purely based on social justice. Social justice, what happens is that we go deep into a man's behavior. Not only what he has done right or wrong, that's a different issue, but we go deep into the subject. We go deep into the subject as to why, how, etc. I'll give a simple example of that. Of course, in my new, when I carry out the Industrial Disputes Act, I will read in detail, but just give a simple example of one thing. Take the example of a person is caught at the gate carrying a material of 20 rupees worth, right? Then it's a thief, it's a theft, right? And let us see the example of another person carrying a material worth of, let us say, 20,000 rupees. Now, he has also committed theft, right? Now, here you got two cases of theft of 10 rupees and theft of 20,000 rupees. Now, here the court will apply this particular aspect. Now, what is the mistake he has done? The mistake what he has done is just 20 rupees. For 20 rupees, can you punish him to the extent of removing from services? Is it commensurate with the act of misconduct? Please apply their mind. That's what the court says. So we have to go into details. And let us say, for instance, a person has compelled to do certain things due to his own personal issues or whatever it is. All along he has been very honest. He has been very hardworking. Everything is done. But today he has done it. The courts will take a view. They said, look, whatever the past records, excellently has maintained, his behavior is good, everything is good. Now today he has done something for that purpose. Why? We had to have a look at the entire thing. Then what they do, they modify the whole thing. I'll give a lot of examples when I do the ID Act presentation. I'll share you all these things. But this is what is called a law of equity, equitable justice. Take the example of our payment of minimum wages. If anybody pays less than the minimum wages, it is violation of Constitution of India in terms of Article 21. Look at here. So if I pay a less wages to a person, we go deep into it. What do you mean by quality of life? Quality of life means one has to lead a comfortable life, right? In all respects, both emotionally, physically, mentally. No, he should have a comfortable life. That is exactly quality of work. But here what happens? Supposing you pay a less wages to him. Now, what happens to his quality of life? He suffers. He can't eat anything. He cannot do anything. He works under pressure. He works under what you call different circumstances, different situations. So here exactly, this is not the intention of the society. You got it? This is not the intention of society. The society intention is that everybody must be able to earn to make their living. So, friends, this is the main difference between the courts of law and courts of just court of equity. Now, all the labor legislation, if you see, all the legislation aim at courts of equity because they go into details. They go into terrible details into it, so many things. So, so this is a peculiarity in the labor legislation. So here what we need to do is we must understand the spirit behind the law. It is not, we have to appreciate the spirit behind each and every law, each and every provision, why it is made, what is the purpose of doing it, what is the intention of doing it. Then it goes on to that. Friend, this is exactly the difference between that and this. Now, as you know, probably we're very familiar now with the Constitution of India. Now, Constitution of India has got a very, very strong bearing on this entire, what do you call, labor legislation. Very strong. Because, as you know, there are fundamental rights in the Constitution. Freedom of association, freedom of, what do you call, equal application of provision of law, no question of exploitation, no question of unequal treatment, and quality of life, and fundamental right to form an association, action operation, all these things are embedded in the Constitution. These are fundamental rights. It is all. Fall in line with the Constitution of India, right? Now take the example of the Equal Remuneration Act. Equal Remuneration Act, it says, it is the duty of the government to ensure that there is no discrimination in payment of remuneration between genders, right? No, there it comes. That's why the legislation called equal remuneration has been made. Like that, the state governments also have been embedded with all these things. So this is one portion of it. And another source of formation of labor legislation in India is ILO, International Labour Organization. Now, India, you know that we are a member of ILO, and not only member, but we have been an active member in the ILO. The ILO is a global body, which they oversee the conditions of labor throughout the globe, and then they advise and give some proper guidelines and standards that is called conventions. They do that. Now, it is for the respective governments to take the convention and then convert into different legislation so that the purpose of ILO is implemented. Understand? This is how the whole thing. Now, take the example of simple. The ILO convention says there shall not be any discrimination in the matter of employment, in the matter of remuneration. Immediately, Government of India, what they did, they formed Equal Remuneration Act. And similarly, they what do you call, to take care of the working conditions of children. Working conditions is a global issue. So immediately what happened, Government of India brought a prohibition of employment of children. They brought a law. Now you can't employ anybody who is less than 18. And if you want to employ anybody less than 18 and 16, you have to go, we've got specific standards of this one. You have to follow that. So like that, for each and everything, this has been done. Now India has been adopted almost all the conventions, The only convention not yet fully what you call done is that only in case of total prohibition of child labor. It makes a little problem because of so many social problems in India. It is not fully done, but to a great extent it is being done. So like that, ILO is also one of the source of labor legislation, force of formulation. So, friends, now you have got now you understand the source of legislation. One is that the commissions before 1931 by Whiteley Commission, one source. It started this whole the starting point of the whole thing. They came there. Then the Constitution of India, another source. Now the ILO conventions, that's another source. Now we got two, three sets of combination of sources of labor laws. That's how today we are in this position. So as I said already, this is a highly dynamic, highly dynamic. Today we feel that one legislation has to become, okay, we have to do it from the point of view of taking care of the society in general, social justice in general, to give justice to everybody in general. So with that immediately we do it. That's why every day we see some new laws are coming, new legislations are coming. So it is coming, all of you are seeing in the newspapers. Take for instance, now today we have got special act being made for uh, protection to disabled persons in employment. It was there earlier, but now today the government wants to make little stiffer action so that the disabled people are not put into trouble. They are all put in trouble and they are also given equal opportunity to work, etc. etc. And friends, this is the whole background of the labor legislations. Labor legislations. As I said already, mainly it has to address the social justice. Number one, the intention is to protect the rights and liabilities of a workman. This is number one. To avoid total exploitation and injustice to workforce. That's another one. And secondly, what happens from the point of view of national economy? See what happens, if the employers are compelled to take care of certain things, follow strict guidelines, and then do all these things, then what happens? The productivity goes up. Naturally, productivity goes up. When the productivity goes up, the what happens? Obviously, the national GDP goes up, national income goes up, and standard living goes up, and there's a positive thing. And more than that, it provides a lot of employment to people. So this is one thing. And third is that the international ILO conventions, we have to stand in line with the global development in terms of human rights, in terms of social justice, in terms of everything. We should be above everybody and we should stand in line with the global operation, right? Now, this is the main purpose of the whole liberalization. I'm just giving a background of it because one, you have to be thorough with how the laws were formed in India, how it developed, why it developed, what is the reason behind it. For that purpose, I made a small brief talk on this, and of course now probably in my presentation also you will see a number of court cases how they have interpreted this one. As I said already, payment of minimum wages is against Article 21 of the Constitution of India. Look at that, and then payment of and another important thing is now you know that a sexual harassment of women is again a what you call a violation of not only section 21 but section 19 and everything also, that's also applicable. And then important thing is that today we terminate people without conducting an inquiry. We terminate people without giving a simple show cause notice even. Now, again, in one case, Yadav versus Rajasthan, the Supreme Court has said very clearly in other Yadav's case that if you terminate a person without providing an opportunity for him, your action is illegal. Look at that. So here, this is where all we comes here. Take the example of strike. The unions will say, right to strike is my right. That's what he says. But the Supreme Court clearly ruled out this. No, it is a legal option given to you to fight against injustice, no doubt. But it is not a right to strike. You don't have a fundamental right to strike like anything else. So it is not a right. So all these things have been laid down by various courts. Maybe you can see all those things. Well, there are any number of thousands of cases to cite on, I don't want to go ahead with this because I want you to read the presentation in detail Probably you would have done it. I suppose you have done it. And then okay, before I quickly go to Payment of Wages Act, anybody has got any questions? Anybody has got any doubts on this one? You would have gone through the presentation material which have been sent to you. You would have gone through. Give me your reaction, then I will go ahead. Okay, 2 minutes. I will give the floor to you.
Sir, I'm Prakash here. I have only one question. See, the documents which was there in the link, you will not be able to download. In case if I want to download, what is the options?
I think Mr. Ramesh.
For downloading, we have not provided the option because if it is once downloaded, it will be circulated widely so that it will affect our course. So we have not given the downloaded options. You can watch it once or twice or any number of times you can watch it.
Yeah.
But some material is required, no, sir, at least, because I don't know whether every time you can go and log in the system and look at the slides.
Prakash, see, you have to refer the bare acts and the available material in the books, because providing material for all the 14 acts, it may go up to the cost like more than 10,000 or 15,000 rupees worth.
Oh. Because this was not aware, before when we registered, because now, to refer it or maybe to take the printout for, referring for any case laws or discussions, because we'll not be able to, check immediately, because again, you need to log in.
We will separately discuss on that, Prakash. I'll talk to you.
Yeah, please, please.
Prakash, what is I'll talk to Ramesh also. Let's see what best can be done. We'll think about it. And we'll try to help you.
No problem. I'll discuss with Ramesh.
But my suggestion is that please go through once, twice, thrice. And with this background, what I told you now, with this background, please go through 1, 2 times. Then you get a broad idea, right? Then in that, if you got any doubts, please make a point and then send an email to me. And then I will clarify immediately. About this request, I will talk to Ramesh. Let's see what best we can do. Okay, right?
Sure, sir.
Yeah. Okay.
Sir, I had a kind suggestion for the course. Sir, if it would be possible that we have regular tests, so then we would be in a.
I was about to come to that. If all of you are agreeable, I will send you objective questions. Okay. Take for instance, today we are talking 3 topics: Constitution and labor laws, and then Payment of Wages Act, Payment of Minimum Act. Covering these acts, what I can do is that I can frame about 50 or even 60 objective questions, and then I will email it to you, right? And then you correct it, you answer it. Yes, they are simple yes or no questions. Then send back to me. Then I will evaluate it and give you ratings for each 3 reasons where you stand. I can give that. In fact, I was about to ask that. It's a good thing you asked me. I will do that. Okay, right.
That would be wonderful, sir. It would help us in.
Definitely. Exactly. I will do that. It will be done.
Sir, Sir, in addition to this, sir, if it would be possible, if you can send us a case study, and whenever we have an interaction, then we can discuss that case study. That would help us in the application in real time.
Yeah, I agree with you. What happens is that it also can be done. There is no doubt. What we will do is that in the appropriate stages in different legislations, I'll give you small case studies. Then you can debate yourself. You can distinguish yourself and make a simple presentation as to what you find out or what is the case about. Because here what happens once you give a case study, you know to understand, you to apply your mind, right? You have to apply your mind. Then you have to make an analysis, threadbare analysis. Then you have to go in details and find a solution of option of 1, 2, 3 or whatever it is. I will give that suggestion also. I will give that.
Thank you very much. Thank you.
Yeah. Okay. Now, payment of beneficiaries, have all of you gone through this? Of course, it's a very simple act. Have you gone through this? All of you?
Yes, sir.
You have gone through.
Yes, sir.
Okay.
Yes,
Because
sir.
why I'm telling you this is that now these legislations from right from this legislation, like for instance, Payment of Minimum Wages Act, be uh, be thorough as much as possible. Okay, in PPT, I have given a very exhaustive, what you call, presentation on minimum wages. But my suggestion is that, particularly Minimum Wages Act, please go through in detail, in depth, number one. At the same time, take the hard copy of the act and also read it. Why I'm telling you this is that in the upcoming labor code, you will be able to understand and appreciate the code once you are thorough with the present acts. Particularly Minimum Wages Act, there are radical changes in the upcoming labor code. So if you want to understand and appreciate the implications of labor code, then you have to be thorough with the Minimum Wages Act. So when the further friends, what I'm telling you is that please read this thoroughly, very, very clearly. So payment of Minimum Wages Act. As you know, there are two, three things. First of all, you understand the definition of wages under the payment of Minimum Wages Act. What is the definition of Minimum Wages Act? At the moment, it is a broad, nothing but a gross salary of a person, excluding certain things. That's the differentiation. And it also stipulates the working conditions. 8 hours in a day, not more than 48 hours. And beyond 48 hours, one has to pay overtime at the rate of double the normal rate of wages, right? And then fixation of minimum wages. Who has got the authority to fix up the minimum wages? The central state, it has been entrusted to the state governments. State government, they form a constitution advisory board, advisory board, and then they give a recommendation to the board and government, and implementation takes place. And then, in fact, in India now, fixation of minimum wages has become a highly problematic issue. It is not possible at all, because what happens, India is a totally diverse nation, right? It's a totally diverse nation. Some people are highly progress, but some people are not at progress. Some states are industrialized, some states are not industrialized. The cost of living from one place to another place varies. In city, a different cost of living. If you go to village, there's a different cost of living. And you've got number of cottage industries. Cottage is small scale industries. They don't have that kind of a, what you call, capacity like any other organized sector. So his payment of wages is a problem for him. So all these issues are a big issue for the state government. But somehow what happens, India has been able to fix the minimum wages based on certain simple criteria right from 1948. It is not a, what you call, a formula-based fixation. It is not a formula-based fixation. Let us say, for instance, last year, the fixation, let us say 10,000 rupees. The next month, after 5 years, the board says, no, 10,000 rupees too less, because our cost of living has gone up, the index has gone up, cost of living index, it has gone up. So inflation is very high, so it has been but how it is to be matched, nobody has talked about it. So based on that, what we do is that we get the reactions from the employer. Take, for instance, a plantation worker. If a revision has to be made, the plantation employer, they will say, so please do not go beyond this, or we can't afford it. The union say, no, we want this. So this is basically the job of the committee, advisory board, and they fix and recommend it. And of course, it goes to court of law and then challenge, all these things happen. So in India, there has become big problem. That has become number one. Now, second thing is categorization of employment. Now, for instance, a person working in a large scale industry, like leading engineering industry, the industry is different. But as a worker is concerned, he gets the same wages. Now, let us take the example of small scale industry, right? A small scale industry employing about 20 people or 30 people. Now, look at his position. Is he able to pay so much of money? Is a question. For that purpose, you probably were aware that in all the states, there are industries are classified. In fact, in Karnataka, if you see, you find about 73, 74 different class of workers, class of employment. So for each class of employment, the government says, you shall pay this, you shall pay this, you shall pay this, right? This is how it is going on. And maybe it's a matter of interest, that current government is the first government to introduce minimum wages for domestic employees. You know, if you are keeping home domestic servants in your home, the minimum wage is fixed there for that. It's the first time in India. Now, of course, all the other states have started adopting this. Now, I am no, this is another complication. Now, here in this code, why I'm telling you this is that you have to be thorough with this. Today, what is the position? Today, how is the system? Today, how it is applicable, right? All these things. And even the wages can be paid by hourly basis. It can be paid by weekly basis. It can be paid on monthly basis, not beyond a month, right? That's exactly that. And penalty, if you don't pay, what is the penalty? So these are simple things, but I want you to thoroughly go through the presentation material, what I said. In fact, in my presentation material, I have cited a lot of case laws also, respective case laws also. You please go through all those things. It will enhance your knowledge on the payment of wages, Minimum Wages Act. Simultaneously, read the Bare Acts, presentation, and this one. Now, here also, please apply your mind because it's very important. The more you apply your mind here, it becomes very easy for you to understand the upcoming labor code. I will tell you at the end of the session, I will explain about labor code, how it is complicated, as per definition of wages is concerned. But the other thing, I will just explain to you another thing. Even today also, the minimum is paid on the basis, unskilled, one level of wages, semi-skilled, skilled, highly skilled, supervisory, and even for that also some classifications have been done. And of course, now, of course, the Minimum Wage Act is limited to only workmen who are defined under the ID Act. That's one thing, right? Today, the Minimum Wage Act is made applicable as per the definition of worker under the ID Act. In a simple word, that a person who is not doing a supervisory job is false under the definition of workman. Of course, we'll tell you in detail when I deal with you the ID Act. Okay. Now, this is the base salient features of the Minimum Wage Act. Okay. Please go through this. Please understand this. Any questions? Please send me an email. Second. Now we come to Payment of Wages Act. Payment of Wages Act. It is only to regulate the payment. So there is a difference between two. Payment of minimum wage is the only legislation which prescribes how much you should pay for a person. This is the only legislation. Where a Payment of Wages Act, it regulates the payment. It means that how you should make the payment, when you have to pay, what are the deductions to be made, what are the authorized deductions, how can you recover a fine from a person, how can you recover a damages caused by a person. So all these things, it is stipulated under Payment of Wages Act is one thing. Right now, please remember the Payment of Wages, the provisions of the Payment of Wages Act are applicable only for people who draw gross salary up to 24,000 per month. That's all. Please keep it in mind, because what happens in the code, there's a radical change in it. That's why, so be thorough with. It's a very simple act. Payment of Wages Act is a simple act, but the basic things, please keep it in mind. And here also, I've given you a lot of case laws in my presentation material. You please go through that, and this will be useful to you. Okay. Just given a brief background of 3 chapters today. Now, if you got any questions, you can ask me, and then before we end this session.
Sir, Vittalrao sir.
Yeah.
We have uploaded only videos and we have not uploaded the PPTs. You please send us the PPTs so that we can upload the PPTs as well, sir.
Ramesh, in my presentation, PPT is also there,
PPT in the video backslide, it is there. In the video, it is showing, but it is clearly they cannot see it, I think.
Oh, okay. I got it. Yes, anyway, I will talk to Ramesh.
Yes,
I will discuss with Ramesh, and what the best we can do, definitely I will do it for you. Don't worry. I understood, because in the video, you're not able to see some PPTs clearly. or some PPTs may be visible, may not be visible,
Yes,
right? That's your
yes,
problem.
yes, sir.
Okay, then I will talk to Ramesh and try to rectify that, and we'll try to help you. Please remember, we will try to help you as much as possible. The intention is that, right? The intention, spirit of this course is that you must be able to understand, appreciate, and then equip yourself with full competency. That's all. Okay, I will help you to the whatever the possible. Definitely, will do it. Yeah.
Because, sir, I have one question. You said the payment of wages act is applicable with drawing less than 24,000 gross salary.
Yeah.
Okay, but if person is independent contributor and his salary is more than 25,000, then still he comes under the ID Act.
No, the ID Act is different. Please do not mix up that. Here, when come to ID Act, I will tell you what is the definition of workman, what is exclusion. There's a different story at all.
Okay.
Only these provisions of Payment of Wages Act, that's all. Right?
Okay.
Only that.
Wonderful.
So that's what I'm telling you. Payment of wages, provisions of payment of wages applicable only for these people. But when you come to workman, non-workman, it's a different thing altogether. Don't mix up. That's a separate issue at all. I will deal with you in detail.
You mean to say when person is drawing more than 24,000, the Payment of Wages Act rule is not applicable to that person?
Yeah, for that purpose. But he will be covered by ID Act also, because he is not in a position of supervisory. He is a workman. Then definitely, even though there are many examples, a person getting, let us take the example of a pilot, air pilot.
Yes.
Air pilot, he draws a salary of, let us say, 6 lakhs per month or 4 lakhs per month. But, he still continues to be a workman under the ID Act. Look at that. So salary is not the criteria. The criteria is the nature of work. Right?
Yeah,
so,
understood.
So let's not fix up that. When you talk
correct. My question is again, if a person is drawing more than 24,000, if I want to make more deduction, the Payment of Wages Act is not applicable, like damages and fines.
Yeah, that's exactly. That's exactly. Yeah. Suppose you deduct more for him, then he cannot raise an issue that my salary is deducted so much, I have to make a complaint. He can't make a complaint out of it because he's not covered under the provision.
Payment of Wages Act.
Yeah, this is exactly.
Understood.
Right?
Sir, another question, is there any tentative date for the wage code implementation?
Oh,
because
no, that's a big question. That's a big question. In my view, I think this may drag on up to March, I can tell you.
Next year, March, sir?
Yeah, because many of the state governments are not ready with the rules. They are not ready. So in all probabilities, it will not be so fast. But please equip yourself.
Yeah.
Please equip yourself and be thorough with it. That's what I'm requesting. Okay.
Sure, sir. Thank you.
Yeah. Okay. You like this session? Is okay for you, all of you?
Wonderful, sir. Wonderful session.
Okay, that's very good. So let's carry on, and then next 2 weeks, after a fortnight, I will meet you once again. I hope at that time you thoroughly go through all the presentation what I made you. In the meantime, I'll talk to Ramesh how I can best help you in providing the presentation material. I'll do that. In the meantime, I'm also preparing a objective test paper, and then I will email to you. And please give your email ID to Mr. Ramesh. Okay?
Sure, sir. Thank you so much, sir.
Okay.
Sir, may you please share your email ID, sir?
Beg your pardon? Email ID, Ramesh, can you
I'll send you in the WhatsApp group, sir.
Oh, yeah, please send it.
Yeah.
Thank you, sir. Thank you.
Okay. So that's all for the day. Okay.
Yes, sir. I think.
Thank you, sir. Thank you so much. It was very informative session.
Okay. Thank you very much.
Thank
all
you.
the best to you. All the best.
Thank you, sir. Thank you, sir.
Right. And ask other participants also to join from next session onwards. Okay. Yeah.
Sure, sure.
For their own goodness, for their own good.
Yeah.
That's all. Okay.
Thank you.
Thank you.
Sir.
Thank you, sir. Thank you so much.
Sir is in the US. Last week only has traveled. From the United States. Sir is taking class and he has joined on time. On behalf of M&HR Learning Academy, I thank
now here
sir.
it is. Now it is morning 7:30 here.
Yes,
Morning
sir.
7:30.
Yes, sir.
Okay.
On behalf of
M&HR
Learning Academy, thank you one and all. Thank you.
Okay. Thank you. Bye. All the best. All the best to you. Right.